Hi, Jim Roddy here from the RSPA, jumping in before today's podcast to make sure you know that registration is now open for Retail Now 2025, the Retail Technology Channel's #1 trade show, education conference, and networking event. Join RSPA and Retail IT channel leaders live and in person July 27th through the 29th on the Strip in Las Vegas at Caesars Palace. With nearly 200 exhibitors, Retail Now is one-stop shopping for VARs and ISVs. And with an expected 1,600 or more attendees, it's the place for extreme industry connectivity. Across just 48 hours, you'll meet new partners and new solution providers who can accelerate the success of your business. If you're serious about the Retail IT channel, you have to attend Retail Now 2025, again, July 27th through 29th in Vegas. Retail Now is where the industry meets. For all the details and to register at discounted early bird rates, visit the Retail Now website today at gorsp.org/retail now. That's gorsp.org/retail now. Enjoy today's episode featuring one of the most popular Retail Now speakers and one of our industry's leading experts on cash discounting and surcharging, RSPA General Counsel Attorney Jill Miller. Welcome to another episode of the Trusted Advisor podcast and video series powered by the Retail Solutions Providers Association. Our goal on the pod is to accelerate the success of today's and tomorrow's leaders in the retail IT industry. I'm Jim Roddy, back with you again. Thank you so much for joining us. Now, today on the podcast, we have a return guest making her record 12th appearance on the Trusted Advisor is RSPA General Counsel Attorney Jill Miller. Jill, welcome back.
Why, thank you. Am I still the one who has the most number?
You are. There would be a lot of catch up. You are by far and away our most recurring guest, I would say. So yeah, you're at an even dozen at this point. Nobody's gotten even close to double digits yet. So congratulations.
Okay, I've got to keep on it. Yes.
Absolutely. And then the next one will be a baker's dozen. So
there we go.
We'll keep putting a gap between you at the top and the rest of the field. So, So now for folks who haven't tuned into one of those prior podcasts, just so you know, Jill's a partner at Detroit-based law firm Bodman PLC. She serves as RSPA legal counsel since 2020, providing advice to all members, but especially VARs and ISVs. Now, that advice is available at no extra charge to RSPA members through phone calls, emails, video chats, and in-person meetings at RSPA events. So Jill's been involved in our industry for several years, counseling clients on data privacy, cybersecurity, card processing, mobile payments, ACH, electronic fund transfers. I'm going to have to take a breath, virtual currencies, and more. Her sessions on cash discounting and surcharging and dual pricing, the past two Retail Now events, were huge hits. So, Jill, what is the topic you want to focus on today? What's something you've been fielding a lot of questions from RSPA VAR and ISV members about? What's something you think they should know about?
I think today we're going to talk about the Corporate Transparency Act, otherwise known as the CTA.
All right. Very good. Tell us a little bit about that and what our members should know.
Sure. Okay. So as Jim mentioned, when I start to receive a lot of questions from our members through email or phone calls about a particular topic, a light bulb goes off and I say, I think it's something we should talk about to the general membership so they have the benefit of the research and the knowledge that I've gained over a particular topic. And Corporate Transparency Act has been a lot of questions I've received from our members. So sort of the history of the Corporate Transparency Act is that in 2021, Congress passed the Corporate Transparency Act. And this law was created as a way in which to fight what Congress and the government would say are sort of bad actors in the corporate world who have received ill-gotten funds and just really trying to sort of protect the U.S. and how funds are used and transferred within the United States ecosystem. And so the Corporate Transparency Act really is about filing information with FinCEN, and it's about the beneficial owners of companies. And it really covers all kinds of companies within the U.S., and foreign entities that are doing business in the U.S. And what that means is companies are, I'll get to the fun stuff later.
Sure.
The requirement of the CTA was that companies would have to provide through a online reporting system that was created by FinCEN, and they would have to list beneficial owners. Now, what are beneficial owners? Beneficial owners are either one of two categories. It basically, I'm reading my notes here because it's some specific language. It refers to the individuals who ultimately own or control the business. And so it's, again, just a specific definition is either you control or otherwise manage, direct the company. For example, a CEO or some other kind of business executive, and anybody who owns 25% or more of that company. So in some companies, you may have 10 owners who only own 10% each, and so none of them would have to be, their information would not have to be provided to FinCEN, but you have to have somebody who's controlling the company. And so that's how, if you have an entity that doesn't have anybody who owns more than 25%, then you go to the prong of who's really controlling and directing the activities of the entity. So there is no maximum number of beneficial owners that can be reported in a beneficial owner situation. And so, as I mentioned, when the CTA was originally enacted in 2021, it wasn't until January 1st, 2024, where they actually set up the e-filing system. And so back then, the law said that for a company who was organized or otherwise registered prior to January 1st, 2024, they had until January 1st, 2025 to actually file with FinCEN on this online reporting portal the information about their company. And for companies that were created or registered on or after January 1st, 2025, those folks had 30 days to file after receiving sort of information that they actually are in existence and the registration was effective. So again, companies that were created or registered in prior to 2024 had until January 2025, and then those companies that were registered on or after January 1st, 2025 had to file within 30 days. Now,
yeah.
If a reporting
so I can just say, so people now are listening going, oh, okay, this should all be done, right? Everybody should have filed by this point because we're recording this in mid-March of 2025 So, but let's say there's the rest of the story, I think, is what you're going to lead us into.
Yeah, I just sort of wanted to give people a background. And there's one group of people that I didn't yet mention, which is anybody who actually was registered and enacted their company in 2024, right? So I didn't yet talk about those folks. We talked about prior to 2024. We talked about after January, but those folks who actually entered and became a company in 2024, they had 90 days in 2024 to do the reporting. So while a lot of various entities were out there, you know, and we talked about this, Jim, in our weekly meetings, you know, there were a lot of companies out there sending emails to companies saying, hey, we can do this on your behalf for such a small fee of X. Now, FinCEN had said in some of their printed documentation that they felt as though a majority of the companies should be able to go on there themselves and just simply file the information. Now, as a law firm, we had a lot of companies come to us and ask us to assist them with the reporting. And initially we were sort of, you know, it seems like a service that we necessarily didn't think was a the best use of our clients' resources. But when they just felt uncomfortable, we said, okay, let's figure out a program. Let's figure out a way to file on their behalf. There are 23 types of companies that are exempted from having to do this filing. And I think for me, the two most common we saw in the last 18 months were nonprofits, otherwise known as tax exempt entities, and large operating companies. So we have clients who fell into this category, and this category was a company who had more than 20 full-time employees and had revenue in excess of $5 million. And you had to have a tax filing to prove that you had the in excess of $5 million in
So
revenue.
the large companies get excluded from this? So
They
it's
did.
more SMBs?
Yes. Yeah, it really was. It really was, I think, part of that. I think because many times some of these larger companies are reporting in other various ways. For example, there has always been, not always since the beginning of time, but there has been, the whole KYC, know your customer. And under the KYC rules, banks have an obligation to collect beneficial ownership information from its customers who want to open an account. And that is, again, another way in which the government was trying to prevent, terrorist funding and things of that nature. So banks and their collection of beneficial ownership has been going on for quite some time, but it is not duplicative of the requirements under CTA. So even if you've applied for a loan and we're saying, I've already provided somebody my beneficial ownership information, that information is not considered filing with the CTA or with the FinCEN for the CTA. So do you have any questions? I can see you hanging on every word here. I can just keep going if you're good. Are you good?
No, yeah, keep going, because it's interesting, because most regulations, it's, it applies to if you're a certain size, but below this threshold,
right,
don't worry about it. But this seems like it's trying to take care of those fake, the shell companies that people put together to try to hide money, is what it sounds like.
You're exactly right. Yes, you're exactly right.
Well, thank you. You sound like I have a lot of experience with that. I have no experience with that whatsoever. I'm just connecting the dots here. So
yes, great. Okay, so the information that a reporting company has to file is its legal name, any trade names, doing business as names, its current address, the jurisdiction of its, where it's actually formed, and then their tax identification number. Now, for the beneficial owners, they have to provide their name, their date of birth, an identifying number from an acceptable form of ID, like a driver's license or a passport. And you actually have to provide a copy of that. And so, now we're getting into some of these privacy concerns, right? And so I think that's another reason why a lot of our clients felt comfortable using a law firm, because we have, privacy policies and procedures in place. We've probably, we've seen a lot more than just their driver's license or passport, in our engagement with them. So that's the kind of information that they were expecting companies to provide. Now, there were penalties also, which I think is where people start to get right a little bit like, oh my gosh, do I have to do something here? And the penalties, when this originally was enacted, were up to $500 for each day that the violation continues. So, for example, right, I mean, if you didn't make the January 1st, 2025 date, although I will just insert this in here now, there was a pause based on some court cases. So don't panic if you didn't do it by January 1st, 2025, because a lot transpired at the end of 2024 through recently. So, but that particular penalty was also going to be increased daily or annually based on sort of a inflation. really based on inflation.
Mm-hmm.
And so in addition to those $500 a day penalty, there was also, if a person willfully violated the BOI obligation,
What is
then
BOI? A beneficiary? What is BOI?
beneficial ownership information.
Okay, got it. All right.
Yeah,
Thank you.
no problem. And so the person who willfully violates the BOI reporting requirements may also be subject to criminal penalties. So the $500 a day is what we call a civil penalty. And then the $10,000 was a criminal penalty and up to 2 years in jail. So I don't care if it's a federal jail or any other kind of jail. No, thank you. So that, that was something that was, I think, weighing heavily on individuals and companies' minds, especially some of the smaller companies. I mean, they're just out there running their business, and all of a sudden, FinCEN is, and the CTA is out in the news, and it's like, what does this even mean, right? Because one of the documents that, is a resource is this, how many pages do we have here? For your reading pleasure, it's on the FinCEN website, 59 pages of, frequently asked questions. So clearly people, were not completely, it wasn't very clear, I think, out there in the ecosystem of what the obligations were for this beneficial ownership information requirement for filing.
Sure. And I'll just share with you, Jill, and for you and for our listeners. So I started my own company, a side business, back in 2019 before I joined the RSPA. I still keep it alive for book sales, professional speaking, things of that nature. And when this came out, there was the element of, like you said, you saw the penalties, you saw prison, and everybody who knows me knows Jimmy wouldn't do well in jail, for sure.
Right.
And so it was scary to be able to say, like, make sure you do this right, make sure you file it, because there were some pretty stiff penalties. So I did file it. I did not use an attorney to do it, but I made sure that that I got it done. So. Yeah, so keep going. I didn't mean to interrupt your story, but I just want to I can relate to the fear that went along with this.
Yeah, I too believe that neither you nor I would do well in jail, which is why we both tend to follow, the laws.
It's true.
Okay, so to get to the punchline here, right? So I've given you all this background of what it is and, what is the CTA and what were the reasons and elements under which filing was required. Now, the punchline is this, that on March 2nd of 2025, the Treasury Department announced not only would it not enforce any penalties or fines associated with the BOI reporting rule under the existing regulatory deadlines, it will not further enforce any penalty or fines, I'm on to my next page, against U.S. citizens or domestic reporting companies or the beneficial owners after the forthcoming rule changes take effect either. So the Treasury Department will be issuing proposed rulemaking that will narrow the scope of the rule. And what they said in their announcement was that it would only apply to foreign reporting companies, which means non-US companies. So that's really the last step. And they also have a quote in their announcement that said, the Treasury takes this step in the interest of supporting hardworking American taxpayers and small businesses and ensuring the rule is appropriately tailored to advance the public interest. And so, this was a law that was enacted that also went through a series of court cases that tried to that issued injunctions, back in late December, really close to the filing, when the filings were going to really start to be put into place. And so it went through, and I have another resource. You could sort of probably Google Corporate Transparency Act timeline, and really starting in December 3rd of 2024, there were 1, 2, 3, and then a whole nother page, 15, 20 different start, stop. And so at one point, our company was issuing client service announcements, trying to give people sort of an updated status, but they were coming so fast and furious, we thought, we might be confusing the matter even more. But, again, as of the 2nd of March, there is a pause. Companies are not going to be penalized for any late filings, but the rulemaking, which really is what instructs the U.S. citizens and the lawyers how and what specifically is going to be the requirement, if any, for U.S. companies. Again, the Treasury Department said that they intend to narrow the scope to only focus on foreign entities, but based on the, sort of prior, let's see now, 3 months of sort of this change and court involvement, we'll see. I think that people are feeling comfortable that things are going to, not be further, enacted, but, like anything, we shall see.
So the short version is, and I know you don't want to give legal advice to exact companies here, but essentially, if you're a U.S. owned, U.S. based business, this is just a whole bunch of, to quote Shakespeare, full of sound and fury signifying nothing is really what it comes down to.
Yeah, and I think it all comes down to this on, March 2nd, the Treasury Department announces the suspension of enforcement of the CTA against U.S. citizens and domestic reporting companies. And so I think it's stay tuned because there are supposed to be new regulations coming out. I would feel very comfortable once those new I mean, obviously, I'm not having any company do anything right now.
Yeah.
But it will be nice to see regulations that specifically states only applies to entities that are foreign, meaning not, not foreign in terms of I'm a Michigan company and I registered to business in a foreign jurisdiction like Nevada or Florida, but rather outside of the U.S. is what the foreign entities are. So that's the update on the Corporate Transparency Act. And I think that if for some reason anything else ever came to light, the members can certainly reach out to me with respect to, should I be hiring this third-party company to help me? You try to save money when you can, but if it does seem very overly complicated and you want assistance, maybe some of those companies might be worthwhile, but it's not an obligation.
And so thank you for that update. And can you also zoom out a little bit? Third-party companies just reaching out to you to say, I'm going to help you with this. It seems like people should be on guard for that, right? Because you and I have worked together where people are reaching out now. Hey, we can book your hotel room for Retail Now at a discounted rate. We'll sell you a list for Retail Now attendees at a discounted rate, or like this, man, you click on this link and we're going to go help you file FinCEN or whatever regulation. It seems like they prey on timeliness and fear, and it's best to stay away from those unless it's a trusted brand or unless the actual source is guiding that direction. Am I stating that correctly?
I think that's right, because some of those companies were still, after the March 2nd deadline or March 2nd announcement by the Treasury, still sending out those emails. And so, and think about it too, one of the requirements is that you're providing that third-party provider with a copy of your either driver's license or your passport. And so now you're talking about your confidential information, and you want to make sure it's a trusted resource, and there should be some sort of agreement between you and that company that says that they will protect your, personally identifiable information. And in the event that for some reason, based on something they do, it's breached, well, then, you should have some recourse.
Great. Thank you for that. So, Jill, we're almost out of time. I have to squeeze in a thank you to our sponsors who support the RSPA community and make this podcast and video series possible. Our platinum sponsor is Blue Star. Our gold sponsors are Cocard, Epson, Heartland, and ScanSource. And then also a reminder, if everybody knows, registration is open now for Retail Now 2025. For those who don't know, it's the Retail IT Channel's #1 trade show, education, conference, and networking event. This year's event is set for July 27th through 29th at Caesars Palace in Las Vegas. You want to register now. VARs and direct independent software developers are eligible right now for an early bird discount. Visit gorspa.org/ Retail Now. And Jill, you're going to be speaking at Retail Now. I know you and we talked about, we'll be on the main stage for a few minutes. You're going to have a breakout, and I believe talking about whatever you want to call it, surcharging, cash discounting, dual pricing, anything in the couple minutes we have left, you can update our audience, any significant changes recently related to surcharging, cash discounting, et cetera.
Yeah, I think that we're still hearing from companies in various states that, California, as an example, has this drip law pricing, which really talks about putting other fees on a receipt that may not necessarily have to do with cash discounting or dual pricing. And so you have to be really careful what you call an additional fee you might put on when we're talking about, I'll just give you some examples of people have talked to me about. One is, that they've put service fee, but in that particular state, if you have the word service fee, it's a direct violation of the law. Or if you have something like service fee, some might consider that to be a tip, and then it should be going directly to the service person who's ever bringing and waiting on you at a food location, for example. So again, always, just reach out to me if you're doing something that's a little bit unique or different, and I can walk you through sort of what our, the published rules are. Visa is constantly putting information out. They have a frequently asked question document, and the laws are, I can help you not interpret maybe, but I can read through the state law and how other companies have interpreted that law in their particular state. So always happy to chat with anybody about a particular program you're considering.
Right. And that ties in with something that you've recommended in your prior 11 appearances on this podcast and speaking at Retail Now and Inspire. Don't say, but George told me it was okay to do it this way. I heard this other company was doing it this way, right? You've got to go to the original source. You've got to lean on somebody who really knows the specifics, the ins and outs. So Jill, if RSPA members want to connect with you, what's the best way for them to do that?
Best way is to send me an email, jmiller@bodmanlaw.com. I've been able to get back to people very quickly and set up a Zoom meeting, and I just love talking to our members. They're so dynamic, and they're so interesting, and they're so thoughtful in how they treat their customers and thinking of ways to help them be successful. So I really love getting on a Zoom with folks. But if you don't want to get on a Zoom with me, I'm happy to do a phone call too. But send me an email first. My number is 734-930-2499. But if you send me an email, I can quickly respond and say, hey, what do these times look like for you? Instead of trying to fit in a call during the middle of the day. So please reach out to me. It would be my pleasure to meet more of our members.
Excellent. Well, that does it for this episode of The Trusted Advisor. If you enjoyed our discussion, be sure to subscribe to the RSPA YouTube channel and the Trusted Advisor podcast so you never miss an episode. Before we go, big thanks again to RSPA General Counsel Jill Miller for sharing her wisdom with us today. Thanks also to RSPA Marketing Director Chris Arnold for his production work, Joseph McDade for our music, and last but not least, thanks so much to you for listening. Our goal at the RSPA is to accelerate the success of our members in the retail technology ecosystem by providing knowledge and connections. For more information, please visit our website at gorspa.org. Thanks for listening, and goodbye, everybody.